Nena Bagcat-Gullas vs. Joselito F. Gullas, João-Marie F. Gullas U, and John Vincent F. Gullas. GR number 264146. August 7, 2023. Facts. On May 5, 2016, Bagcat-Gullas, together with her husband Jose R. Gullas, filed a petition for adoption and correction of entries in the birth certificate of Joe and Maria Herrera. The case was raffled to the Regional Trial Court, Branch 24, Cebu City, and was docketed as Special Proceedings Number R. CB 16-02302 SP. Joanne's biological mother is Setyasia Herrera, and she has no known father. She and her mother lived at the house of Bagcat-Gullas and Jose, who supported them because Seti had no source of income. For unknown reasons, Seti left Joe and never came back. Despite diligent efforts, Bagcat-Gullas and Jose failed to find Seti. From then on, they provided Joe with all of her needs and showered her with love and care as if she was their own child. On October 24, 2017, the RDC issued an order finding the petition for adoption to be sufficient in form and substance and set it for hearing on December 1, 2017. The RDC ordered that a copy of the order be published once a week for 3 consecutive weeks in a newspaper of general circulation in the cities and province of Cebu. The RDC further ordered that the offices of the Solicitor General, the local civil registrar of Cebu City, the regional director of Department of Social Welfare and Development, Cebu City, and the RDC social worker be furnished copies of the petition and the order. The RDC social worker was directed to conduct a social case study on Jose and Bagcat-Gullas, the minor sought to be adopted, and the latter's biological parents. When the case was called for hearing on December 1, 2017, the petition was read thrice in open court. No person objected to or filed any opposition. On May 18, 2018, the RDC rendered a decision granting the petition for adoption. On June 6, 2018, the Wee Lim and Salas law firm filed an entry of appearance for the respondents Joselito F. Gullas, João-Marie F. Gullas U, and John Vicente F. Gullas, collectively, the respondents, children of Jose. Issue: whether or not the children of Jose who are 10 years old and above are indispensable parties in a case for petition for adoption. Held. Even on the merits, the petition must fail. Section 9 of RA number 8552 provides, c. The legitimate, adopted sons/daughters 10 years of age or over, of the adopters and adoptee, if any. The law could not be any clearer. The consent of the adopters' legitimate children, who are, at least, of the age of 10, is required for the petition for adoption to prosper. In the case of the respondents, it is undisputed that they were all over 10 years old at the time of the adoption proceedings. Their written consent, therefore, was necessary for the adoption to be valid. In this regard, the court in Castro v. Gregorio ruled, the consent of the adopter's other children is necessary as it ensures harmony of future siblings. It also sufficiently puts notice on the other children on notice that they will have to share their parents' love, care, and future legitims with another person. The respondent's interest is material as an adoption decree not only affects the rights of the adoptee vis-a-vis the adopter, but also the rights of the other children of the adopter, Jose in this case. Furthermore, it is not enough to rely on constructive notice. The respondents, as children of Jose, should have been personally served summons by the trial court. Without impleading the respondents and absent service of summons upon them, the judgment rendered by the RDC granting the petition for adoption is void.